Hello, friends. This is Dr. Shashi Agarwal. You are watching Shashi Agarwal Economics and Law classes. So, today our subject is business law, and the chapter is 1, Nature and Classification of the Contract, which we are going to cover in two parts. And today we are going to understand a very important topic. All contracts are agreements, but all agreements are not contract. And the question could also be asked in this form: define the nature of the contract, or explain the nature of the contract, and also discuss the essential elements of a valid contract. If you find my video useful, please do like it, share it, comment it, and also subscribe my channel Shashi Agarwal if you have not earlier subscribed. So this is my app, Adusum app, which you could download from Google Play Store. It provides free study material, free mock tests to the student of commerce, economics, and management. And there are many structured courses like business law is also available. If the question is asked in the examination, all contract are agreement, but all agreements they are not contract, how we are going to write in the examination? First of all, we are going to write the meaning of the contract, what are the elements of the contract, and then we are going to explain agreement is a wider term which covers the social agreement, domestic agreement, and the legal binding agreements. So the agreement which is having essential which are present under section 10, that is going to be a contract, otherwise it is not a contract. So these are the essentials of the valid contract which we are going to discuss. First of all, we should be clear about the meaning of the contract. Contract is an agreement to do or not to do an act. Contract is a legally binding agreement which is enforceable at law. It means there should be two parties, and if the one party breach the terms of the contract, the other party has legal remedy. It could go to the court and sue the party, the one who violates the terms of the agreement. Section 2H of the Contract Act defines a contract as agreement which is enforceable by law. Salman, a contract is an agreement creating and defining the obligation between the parties. Contract is an agreement which creates and defines the obligation between the parties. Sir Frederick Pollock says every agreement and promise which is enforceable at law. So we could call the contract is an agreement, but it should be legally enforceable. So these are the two essential elements of the contract. First, it should be an agreement. Agreement means the one party makes an offer, the other party accepts it. There should be minimum two parties. And second thing, it should be enforceable by law. If it is not enforceable by law, then it is not a contract. So agreement has been defined under section 2E of the Indian Contract Act 1872. Agreement is every promise and every set of promise forming the consideration for each other. Like A makes an offer to B. I will paint your picture. You give me 200. So B accept the proposal. So here A makes a promise with B that A will paint a picture of B. And B, for painting the picture of him, he will give 200 rupees to A. So A is getting 200 for the consideration for the painting of the picture. And B, for giving 200, he is getting in return, his picture is painted by A. So agreement is every promise and every set of promise forming the consideration for each other. A promise is defined in section 2B, a proposal. When it is accepted, it becomes a promise. Like A makes an offer to B. When B accepts the offer, then it becomes the proposal. Then it becomes the promise. When a party makes an offer to the other party, then it requires the existence of two or more persons. There should be plurality of the persons. And second, the party, they should have the legal intention to create the relationship. The parties must have a common intention about the subject matter. It means the subject matter on which the agreement is based, they should have the common interpretation. We call it consensus ad idem. The parties to the agreement must have agreed about the subject matter in the same sense and at the same time. Like A makes a proposal, I want to sell you my red car. A wants to sell his red Maruti car, but B interpret that A wants to sell his esteem car. So here the subject matter, the interpretation of the subject matter is not the same, so it is not a contract. So agreement means offer plus acceptance. Then it becomes the promise, and the promise should be supported by the consideration, and the agreement should be legally enforceable. Then it becomes the contract. So contract has two elements, agreement, and second, it should be legally enforceable. Enforceable at law means an agreement to become a contract must give rise to legal obligation. The party should have the legal remedy. If one party breached, the other party could go to the court and sue the party which violates the terms of the agreement. So contract is an agreement. One party makes an offer to the other and the other party accepts it. Then it becomes the agreement. Then it should be enforceable by law. When somebody says, I will sell my house to you for rupees 10, here the intention is not to create any legal relationship, so it is not a contract. Balfour versus Balfour, it is a famous case. Mr. Balfour was employed in Ceylon. Mrs. Balfour, due to ill health, has to stay in England. She could not come to Ceylon with her husband. Mr. Balfour promised to send her £30 per month while he was abroad, but Mr. Balfour failed to pay that amount. So Mrs. Balfour filed a suit against her husband. She went to the court and filed a suit against her husband. Here the court held it is a domestic agreement. So both husband and wife, they do not have any intention to create legal relationship. So it is not a contract. Agreement is a wider term. It covers the social agreement or domestic agreement, even the agreement which are legally binding. So here, all agreements they are not contract, but all contract they are agreement. All agreements they are not contract. Only those agreements which are enforceable by law are called contract. The term agreement is wider in the scope because agreement covers the social agreement, domestic agreement, and the agreement which is legally binding. So all we could say all the contract are agreement, but all the agreements they are not contracts. Agreement which are not enforceable at law are not contract. Agreement is a wider term. It covers social and domestic agreement. Like A invited his friends for dinner at a restaurant. His friends they reached at the restaurant, but A was not there. So the friends came out without having a dinner. So they wanted to see his friend A, but they could not sue because it was not a contract. It was a social agreement. So agreement to be enforceable by law must possess the essential elements of the valid contract which are mentioned in section 10 of the Indian Contract Act. Section 10 of the Indian Contract 1872 enumerates the essentials. If they are present in the agreement, then it is called the valid contract. So all agreements they are contract if they are made by the free consent of the parties, competency to enter into contract for lawful consideration, lawful object, and the agreement is not declared to be void. In terms of section 10 of the Act, all agreements are contract if they are made by the free consent of the parties. The parties they are competent to enter into contract, lawful consideration, lawful object, and the meaning of which is certain, and there is a possibility to perform. So these are the essentials of the valid contract: offer and acceptance, pre-consent, lawful consideration, capacity of the parties, not declared to be void, possibility of performance, certainty of meaning, which we are going to understand one by one. So there should be minimum two parties. A contract should involve minimum two parties. One party make the offer, the other party accept it without any condition. A contract could be made by a natural person, by any other person which is having legal existence. A firm could also enter into contract. A company could also enter into a contract. So a natural person could also enter into a contract. In the case of state of Gujarat versus Ramlal and Company, when on the dissolution of a partnership, the asset of the firm they were divided among the partners. The sale tax wanted to tax the transaction. The court said it was not a sale because it is the joint ownership. So the partners they could not be both seller and buyer in this situation. There should be two parties. One party should make an offer and the other party should accept it. And there should be offer which is made by one party and the other party accept it. And it should be lawful offer and lawful acceptance. And the acceptance should be without any condition. Must be lawful offer by one party and lawful acceptance of the same by the other party. Here we see A is making an offer to B. He wanted to sell his bike by rupees 50,000. So A makes an offer to B and B accept the offer. Here the party they have intention to create the legal relationship. So it becomes a valid contract. Party must intend to create legal obligation. There should be intention to create the legal relation. If the intention to create the legal relation is missing, so it is not called a contract. Agreement is a wider term. It covers social and domestic agreement also. So these agreements they are not recognized in the court of law. They are not contract. Like you are inviting someone to at your home for tea party. If you are not offering the tea, they cannot sue you because it is a social agreement. So Balofar versus Balofar. Mr. Balofar was employed in Ceylon. Mrs. Balofar, owing to ill health, has to stay in England, could not accompany him to Ceylon. Mr. Balofar promised to send her £30 per month while he was abroad, but Mr. Balofar failed to pay that amount. So Mrs. Balofar filed a suit against her husband. The court held that it is just a domestic agreement. So there should be lawful consideration. First of all, we should be clear about the meaning of consideration. Consideration means what we are getting in return. Like A painted a picture of B and for that B paid him 200. So B gave 200 rupees to A. So A painted picture for him. So consideration what you are getting in return. Like A painted picture, he is getting in return 200. So B giving 200 and in return he's getting his picture painted. The agreement there should be we should get something in return. It is an essential element in a contract and the consideration should be lawful. Gracious promise, the consideration is missing, they are not enforceable at law. Consideration must be lawful. It should not be forbidden by law. Section 23 states that the consideration and the object should not be unlawful. An agreement without consideration is void under section 25. There are certain exceptions which we will cover in the chapter consideration. A promise to obtain for B employment in the public service. B promised to pay 10,000 rupees to A. So here the consideration is not lawful. It is unlawful. If the B gets the job and A demands money, if the B did not pay the money, so A will not be able to go to the court. So the consideration should be lawful. A promise to obtain for B employment in the public service and B promised to pay 10,000 rupees to A. The agreement is void as the consideration is unlawful. Capacity of the parties. The party must be competent to enter into contract. Section 11 of the Contract Act states the following person they are competent to enter into contract who is the age of the majority according to the law to which he is subject. He should be of sound mind. He should not be disqualified by the law. The person who are not competent to enter into contract, the person who are minor, the person who are of unsound mind, the person who are disqualified by the law. A minor, lunatic, idiot, a drunkard person cannot enter into a contract. Pre-consent means the party must have agreed upon the same thing in the same sense. Consent means, and the consent should be free. It should not be caused by coercion, undue influence, fraud, misrepresentation, and mistake. If the consent is not free, then the contract is voidable at the option of the party whose consent is not free. Consensus ad item means the minds of the both party must understand the subject matter in the same way. Two parties must have agreed about the subject matter of the contract at the same time in the same sense. Like A wanted to sell his red Maruti car, but B accepted the offer intending it to be registered. So here it is not a contract because there is no consensus ad item, and the object should be lawful. The purpose for which the contract should be lawful. If it is not lawful, then it is not a valid contract. Section 23 of the Contract Act states the object of the contract should not be forbidden by law. It should not be fraudulent. It should not involve a injury to the person or property to the person. The court regarded immoral or opposed to public policy. And the agreement not declared to be void. An agreement must not be one of those which have been expressly declared to be void by the Act. Section 23 to 30 explains certain types of agreements which have been expressly declared to be void. Certainty of meaning. According to Section 29 of the Contract Act, terms of the agreement must be clear and they should not be vague. A vague means which are not clear. A agrees to sell B 100 tons of oil. So here it is not clear which type of oil he wanted to sell. If A deals in one category of oil, then it is okay. But if he's a dealer of many kinds of oil, then this is a vague agreement. And there should be possibility of performance. If the act is impossible in itself, physical or legally, it cannot be enforced by law. Section 56 of the Contract Act states that agreement to do an act which is impossible, that is void, that is not a contract. A agree with B to put life into B's dead brother, so this agreement is void. If required, legal formalities should be carried on to make it a valid contract. If the required legal formalities are not done, the agreement will not be a valid. All the above elements they should be present. If any of the above essential element is missing, then the contract is either voidable, void, illegal, enforceable in the eyes of law. So, what are the legal formalities? To be a contract, the agreement may be oral or in writing. If any legal formality is required, then it must comply with the necessary formality as to writing. Like in case of we want to sell immovable asset, then it should be proper registered and it should pay the proper stamp act under the Stamp Law Act. When a particular type of contract required by law is to be in writing and registered, it must comply with the necessary formalities, writing, registration, attestation, etc. So it is essential for the validity of the contract. It must be in writing. It must be properly signed and attested by the witness and registered if so required by the law. If the legal formalities they are not missing, they are not done as per the law, then it is not a valid contract.